Well, I want to begin. Actually, you stole a page out of my first day common law class, which is, what becomes known in the class as Alt's axiom. Everything I like, and that goes for everyone, or that you like, isn't in the Constitution, and everything in the Constitution you may or may not like. But that's not really relevant to the underlying inquiry. So we begin on the same page. And much of what Congress or this administration may do, I may not like, but may nonetheless pass constitutional muster. I disagree, though, as to whether or not this does, and certainly whether or not it's clear. Let me just go through and address a couple of points he made before saying, offering, for instance, just to show that I am a fair dealer on this. I will even offer my advice to Pelosi and the Obama administration as to how it is that they could have passed this bill in a constitutional fashion. But to begin with, on the history, yes, we had sort of this history of the court going through with the varying definitions of what was commerce. The good professor suggested that there was somehow not, we ended up parting from this structure because there was somehow not a judicially cognizable standard, that this was not, he seemed to suggest two things. One, that it was difficult to come up with a judicially cognizable standard, or two, that it's ultimately a democratic question. If this is a democratic question, then there certainly are a lot of other questions that would seem to be democratic in nature that the court get in all the time, particularly with regard to war powers cases where that's expressly delegated almost exclusively to the executive. So I'd certainly be willing to have this conversation, but we would end up stripping an awful lot of questions away from the court if we adopt the standard that judicial review is somehow that thin. But as to whether or not a judicial standard is acceptable, no, that's not why we broke away from it. We broke away from it because of the switch in time that saved nine. We wanted a more robust federal government, and ultimately the court acceded pusillanimously in the request of the FDR administration towards this sort of new grand administrative state. With regard to the switch in '95 that saved the Commerce Clause, the court finally simply said enough. We may not get back into a production-distribution kind of dichotomy, but we're at least going to say that there are certain things that are not commerce. And one thing that he said that was not true with regard to Lopez is they didn't dance too much on the head of the pin as to whether or not this particular gun might have been intrastate, because it was in the factual record of the case that it was not intrastate. It actually, the individual had transported the gun across state lines to bring it into Texas. And so it was actually a fact of the case that the gun had transported interstate, but it was not commerce. And that actually is the key, and that's the key here. It was not a commercial activity. The act of transporting something across state lines was not sufficient to transform it magically into commerce, and therefore, or more particularly, the act of carrying it on a school zone was not commerce, and that was the key to the case. With regard to Raich, again, the key here, many people think that it goes to Scalia tends to be, despite the fact that he tends to have sort of relatively libertarian disposition on certain criminal cases, he tends to be one of the largest proponents of the rule of lenity, for instance, which makes him actually, in some cases, a defendant's best friend, a criminal defendant's best friend. But in many cases, in drug cases, he tends to be fairly harsh. So one legal realist gloss on the case is, well, it was a drug case. And in drug cases, Scalia tends to drop the hammer. And, there may be something to that. There may not be. I tend to avoid trying to sort of get to that kind of, reading people's justices' minds. Again, though, rather than sort of saying, oh, it's because it looks like something like medical care, no, it looks like something where counsel conceded the key fact in the case, which is to say Randy Barnett got up in court and said, yes, Congress can regulate the possession and distribution of drugs, but in this case it didn't travel in interstate commerce. And the court did what it has done every time someone makes one of those claims. They said, no, If they can regulate the larger class of economic activity, then the individualized instance we're going to permit. That is Wickard. That is Raich. That is not Lopez, and that is not Morrison. Lopez and Morrison, they did not make the underlying concession. They said that, in fact, no, you can't regulate the underlying class of activity. The underlying class of activity of carrying a gun on a school zone, or the underlying activity of violence against women, and tort claims arising therefrom. Those things are not economic in nature, and they're certainly not interstate economic in nature. And so, in both of those cases, you had facial challenges to the bill in which the key concessions were not made. Whereas in Wickard and Raich, you had cases in which the council basically gave away the farm by saying Congress can regulate this. If you look as well in the case that he talked about, the Oregon case with regard to licensure, here again, as you were listening, it should have sounded relatively similar to my arguments with regard to the state driver's license and insurancing system. Here you've got Congress has a comprehensive regulation of the drugs, in this case through the FDA, and in order to get this particular get access to this particular license, they put a number of restrictions upon them, and the fact that they would have. And there are already existing restrictions with regard to dispensing procedures and carbon copies and what you have to turn over to the DEA with regard to your prescriptions, the detailed record keeping and so forth, and if you overprescribe and so forth, you can have your license pulled. Well, in this case, we simply define giving drugs for the purposes of hastening death to be one of the prescribed activities. That ends up looking an awful lot like some of the restrictions that we have with regard to using the public roads. You're getting some sort of a public benefit associated with this. Again, that looks very different than regulating you breathing, because the interesting thing here is the restriction, the mandate is not contingent upon your accessing medical services. They could have done that. They chose not to. They chose to do it based upon whether or not you have or don't have insurance at any given time, at any given month. Now, again, as I promised, there are multiple ways they could have actually passed this that would have been constitutional. The easiest one would have been in the post-New Deal era, simply to make it a large federal program. I work at the Heritage Foundation. I would have disliked that immensely. But they could have issued a general tax. They could have made a single-payer plan. They could have taxed you in order to pay for it through private providers. But they chose not to do that. They chose not to do that because that would have been politically unpopular. Regrettably, the Constitution doesn't have well, you can violate it if it's politically unpopular and impose it in a different way, which allows it to appear that A, you're not increasing taxes that much, and B, you're not increasing the size of government but quite as much. So again, something which, to my mind, might have even been more stupid may, in this case, be more constitutional, but in fact, I think the fact that Raich involved drugs says less to do about how it is that the health care bill will fare, given the fact that drugs have something to do with health, and it has more to do with the question of whether or not this claim should be raised as a facial challenge versus an as-applied challenge. And in this case, those who are challenging the bill, there are a few who have done as-applied, but most of the major challenges are facial, saying, in fact, the larger class of activity, being not purchasing insurance, is itself not an economic activity. And at that point, it begins to look a lot more like Lopez and Morrison. Thank you.
Well, Professor Ault thinks that the problem here is really one of bad lawyering. The lawyers screwed up in Raich and the Oregon against Gonzalez case, and the lawyers were much better in the Morrison case and the Lopez case. as applied versus facial challenge. That's the distinction. And I think those are both boogeymen. Neither of those is that important. The lawyers were not bad in a couple of the cases, and they weren't good in a couple of the cases. The lawyers were excellent across the board. And whether it's a facial challenge or an as-applied challenge, that's a commonly misunderstood problem, which I think still to this day is misunderstood. That's a non-issue, because what the lawyers are going to do in these cases is they're going to file both. So it just doesn't matter. I mean, there's just no way to distinguish the relevant precedents on bad lawyering or facial versus as-applied grounds. It just doesn't add up. What's important that comes out of the Raich case, the marijuana case, is this. The Supreme Court in the Raich case, 2005, majority opinion, which included Scalia, okay, a very important vote, included Kennedy, another very important vote, readopted, if you will, the so-called rational basis test. In the Lopez case, which was the Gun-Free School Zone Act case, and the Morrison case, which was the VAWA case, the Violence Against Women Act case, the Supreme Court majorities had apparently replaced the rationality test with a substantial connection requirement, which almost required factual proof, which was the antithesis of what the Supreme Court had done with the Commerce Clause for 60-plus years. In the Raich case, the Supreme Court goes back to the rationality model, which is a hypothetical standard. You don't need fact. All you need to do if you're Congress is show that the regulated activity can be rationally connected to interstate commerce. And you know what? You can make it up as you go along. And you know what, Congress? You don't even have to make it up. Your lawyers can do it for you. So given that rationality approach, which is the approach today, the approach that Scalia and Kennedy both joined, I just can't fathom a serious challenge to the Obama administration's regulation of health care. It seems to me to be a pretty simple rational basis argument. Now, in addition to the Commerce Clause, there are other arguments that have been made. One argument is Congress has violated the Taxing Clause. Another argument is Congress has violated the Spending Clause. Unlike commerce, the Commerce Clause, which is limited, we don't know exactly what the limits are, but we all agree it's limited. Taxing and spending are not. The framers in 1787 gave, in addition to commerce power, to Congress the power to tax and the power to spend for the general welfare. Not limited to commerce, not limited to postal roads, not limited to anything, only limited to general welfare. The Supreme Court for a long, long time, and this goes even back beyond the switch in time in 1937, has given that general welfare requirement a very broad reading, and in fact today applies a rationality standard to that. Bottom line, Alexander Hamilton's interpretation of general welfare won the day. James Madison's interpretation was rejected by the Supreme Court. The Supreme Court says that the General Welfare Clause gives the Congress the power to tax and spend for anything. Now, there was this capitation requirement on taxation, and to this day, nobody knows what it means. The Supreme Court, at one point in the late 19th century, gave it some meaning in terms of taxing corporate income, but we solved that with the 16th Amendment. The 16th Amendment now allows the Congress to tax any income. So there still is this capitation problem, but it has never been enforced by the Supreme Court, and to this day, we don't know what it means. That's not a serious limitation. For the court to rely on that to strike down Obamacare would be like a 200-yard wide asteroid striking the Earth tomorrow. It could happen, and it happens once every 200, 300 years, but you know what? It's not going to happen tomorrow. It's just not. It's impossible. That one ain't going to win. Spending, again, Congress can spend for the general welfare, and there's no capitation limitation on that. Congress can just spend. Can Congress attach conditions to the expenditures? Sure, but they only have to be rationally related to the expenditures. Again, it's a hypothetical requirement, and Congress is going to win that. Taxing and spending are additional powers given to the Congress on top of commerce. So even if Congress were to violate maybe the capitation clause with the taxing measure, Congress could still do it with commerce anyway. So that's just not going to win the day. Bottom line, all of these arguments are are stretches. And if, I were a betting man, I wouldn't go to Las Vegas